Imagine being a dedicated government employee and working for multiple years, being due for promotion, but not even being considered for it. This will make anybody frustrated. And that is what exactly happened in the Kulwant Singh case, wherein the Punjab and Haryana High Court has stepped in and once again clarified the matter of the right of being promoted. Hello students, welcome to Drishti IAS. My name is Saloni Nandkyoliar. Today let us understand what this case is all about, what does the constitution say, and what has been the judicial evolution so far. Now before we get started, very quickly I'll tell you that we have this course for you, which is the Studio GS Foundation live online course. Here you're going to get a complete coverage of your UPSC prelims and mains syllabus in 14 months. So you get 1250 plus hours of classes, printed class notes and live chat facility also during the classes. And you'll also have 3 mediums that you can choose from, which is Hindi, English and English. So don't wait, the admissions are already open. You're getting all of this at rupees 34,999 only. And if you wish to avail a further discount on this fee, then you have to use a coupon code, which is SALONI, Saloni, all in capital letters only. So for any more information that you require, please call us at 87501 and you can also download the Drishti Learning app. Now let's get back to our topic and discuss the case. So what happened is that Kulwant Singh was a junior engineer in a government organization and he was due for promotion. But his case was not even considered by the Departmental Promotion Committee. He was discarded, his case was discarded, he was not even considered for promotion, citing some ineligibility criteria, that is education qualifications were not up to date and he was not eligible for being considered for promotion. This is what the committee said. But Kulwant Singh challenged this. He said that no, this is not right, I am eligible. The state is misreading its own rules, it is reading them very narrowly. There is some confusion over here and they are wrongly putting me out, throwing me out of this entire promotion race. So he reached to the Punjab and Haryana High Court. He appealed to the court and he said that I am not being considered for promotion despite my seniority. This is wrong and the court should intervene. And that is what the court did. It intervened because here a core question was being asked, that this government employee, Kulwant Singh, does he have the right to be promoted because he is senior? Does he have the right to be promoted, or does he have the right to be considered for promotion? So this was the core question, that there is this government employee who has been serving for years, he's now due for promotion. So simply because he has served that seniority, does he have the right to be promoted, or does he have the right to be considered for promotion? And that's when the court intervened and said that employees cannot suffer due to administrative delay or arbitrariness. If they are eligible, they must be considered for promotion. So it basically upheld the judgment that was given in the Ajit Singh case of 1999, wherein the right to be considered for promotion is a fundamental right of all government employees. The right to be considered for promotion is a fundamental right, whereas the right to be promoted is not a fundamental right. So even if you have completed the years of seniority, you will be promoted just because of that, just because you're due for promotion. No, that is not a right, that is not a fundamental right that you have, but you will be given a fair chance. If you are eligible, you will be considered for promotion. In this case, Kulwant Singh was not even considered for promotion. His case was not even taken up by the departmental committee. That was wrong, that you are arbitrarily keeping him away from the promotion race, which is incorrect. He has a fundamental right to be considered for promotion. And if after that, if out of all the candidates, if you feel that somebody else deserves the promotion, somebody else gets it. It is not necessary that he will get the promotion, but he must be considered for promotion. There must be a free chance that should be given to everybody who's eligible for promotion. So this is what the court said, and it upheld the judgment. This judgment, the right to be considered for promotion is a fundamental right, was given in the Ajit Singh case of 1999. And this was in accordance with what our constitution says. So our constitution says that everybody has a right to what? Right to equality, that the state cannot act arbitrarily against anybody. Everybody is equal in the eyes of the state, in the eyes of the law. Article 14 and Article 16, Clause 1, that everybody has a fair chance in terms of public employment. You cannot arbitrarily keep somebody away, restrict somebody from being employed in any government organization, in any public employment. A fair chance has to be given to all the citizens. Article 16, Clause 1 and Article 14 were upheld by the Constitution. So this is what the Punjab and Haryana High Court said. Now this also brings up another important question that has been of reservation in promotion, because this was the core question. This was the core question in the Ajit Singh case that we just referred to. So this also becomes important for our examination. In fact, there has been a history of tussle between judiciary and the parliament when it comes to reservation in promotion, and some very significant cases like the Indira Sahni case or the Nagraj case or Jarnail Singh case have been there. So it is important for us to revise that also. The evolution of judiciary based on the earlier judgments. So what happened? For that we'll have to go back to 1992. The Indira Sahni case. Indira Sahni case, wherein the court said that the reservation in promotion for SC and ST does not exist. They said that reservation is only going to be there for recruitment, for the initial recruitment, but it will not be there in promotion. So no promotion, reservation, no reservation in promotion for SC, ST employees. This was said in the Indira Sahni case of 1992. But this did not sit well with the parliament. So the parliament came in with an amendment, the 77th constitutional amendment, and it introduced Article 16, 4A. Article 16, Clause 4 was for special provisions that will be provided to ST and STs in cases of recruitment, initial recruitment in public employment. Then it introduced 4A, wherein this reservation in promotion was granted. Reservation in promotion, which was restricted in the Indira Sahni case, it was granted by the 77th Constitutional Amendment Act. This happened in 1995. Now we go to the Ajit Singh case. What happened in the Ajit Singh case? In the Ajit Singh case of 1999, an SC/ST employee got the reservation in promotion and they got promoted first in comparison to a general candidate employee or the general employee who had seniority. He had joined the service before the SC/ST employee and he had served the organization, but he was not promoted because there was no reservation for him. But the reserved category candidate got promoted before him. So he reached out to the court that I was senior, but this person got promoted before me, whereas I still am at the same position. So this was the Ajit Singh case wherein the court brought out a very important rule, which was the catch-up rule. The catch-up rule. So if a reserved category candidate and a general category candidate both are due for promotion, but the reserved category candidate got promoted first because of reservation and the general category candidate got promoted later on, then this person, the general category candidate, is going to catch up to the seniority and will regain his original seniority over the reserved category candidate. Because originally, who was senior? Who was senior? The general category candidate. but the reserved category candidate got promoted first. Now later on, when this category is also going to be promoted, he is going to regain his original superiority, his original seniority to the reserved category candidate. This was the catch-up rule given in the Ajit Singh case. Now again, this did not go well with the parliament, and the government came up with a new amendment. They felt that the rights of STs and ST were being violated, and they came up with the 85th Constitutional Amendment Act, which talked about consequential seniority. Consequential seniority, that you're going to remain senior by the consequence of being promoted earlier, which means that a reserved category candidate, if he has been promoted earlier than a general category candidate, then that candidate is going to regain, it is going to retain its original seniority, it is going to retain its consequential seniority because he has been promoted first. So in this case, the reserved category employee is going to retain the seniority. So the catch-up rule was weakened because now the reserved category candidate is going to retain the seniority as a consequence of being promoted first. This happened in the 85th Constitutional Amendment Act. And then came in two very important judgments, which were the M. Nagaraj case and the Jarnail Singh versus Lakshmi Narayan Gupta case. Two important judgments came in wherein the court again intervened, and the court said that okay, you want to keep consequential seniority, keep it, but the state will have to prove certain conditions. Those conditions are, number one, that the backwardness of the reserved category candidate should be proved. Number one, their backwardness should be proved. Number two, there is inadequate representation of reserved category candidate in promotion, that has to be proved. The inadequate representation, all this has to be proved by the state. So the inadequate representation has to be proved. How will you prove it? By quantifiable data. You produce data that there is inadequate representation, and all this should not undermine the administrative efficiency. That the person who is being promoted, the reserved category candidate who is being promoted, is not going to undermine the administrative efficiency. He is not going to bring down the administrative efficiency. That is well deserved, is something that you will have to prove. The state will have to prove. This came in the M. Nagaraj case. But then a core question comes in. You have to prove the backwardness of reserved category. Now, the constitution itself has validated that SC, STs and other backward classes are backward. Then why do we need to prove it again? It has already been validated by the Constitution of India. How will somebody prove it again? So a person is belonging to the backward class. The backwardness of that person is already proven just by the virtue of him or her being an SC or ST candidate or an SC, ST employee. So this was done away with in the Jarnail Singh case, while all the others, these three still remain. So these were certain conditions that were imposed on the state, that you want to keep consequential seniority, please keep it, but fulfill these conditions. But in the Jarnail Singh case, this condition, the backwardness condition, was striked off, but the other three conditions were kept. So what is the current law? Is there reservation and promotion? Yes. Is there consequential seniority? Yes. Has the catch-up rule been weakened? Yes. All of this is happening. There is consequential seniority, but the state will have to fulfill certain conditions, and these are the three conditions. If the state is found not fulfilling these conditions, then in that case the court can again intervene, and it can basically invalidate that promotion, the promotion of the reserved category candidate. So this has been the entire tussle between judiciary and the parliament. Amendments have been coming in, judgments have been coming in, but all of this is very important for our examination to understand where do we stand right now. And the Ajit Singh case in particular becomes important for us. So what is the fundamental right? Is the right to be promoted a fundamental right? No. But the right to be considered for promotion is definitely a fundamental right. And if the state is arbitrarily keeping you out of the process of promotion despite you being eligible for it, that is a violation of your fundamental rights. So that was all for this discussion. I hope you enjoyed the video. Now we will look at a practice question for prelims. With reference to the right to be considered for promotion in public employment in India, consider the following statements. 1. It is a fundamental right under Articles 14 and 16 of the Constitution. 2. A government employee has a fundamental right to be promoted if found eligible. 3. Denial of consideration for promotion can be challenged as arbitrary state action. Choose the correct statements. A. 1 and 2 only, B. 2 and 3 only, C. 1 and 3 only, or D. 1, 2 and 3. Please attempt this question and provide your answers in the comment section. Thank you for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.